Hi everyone, this is CA Harsha Buddala. Today we are going to discuss a very interesting topic called interlinking between the Doctrine of Basic Structure as well as the 101st Constitution Amendment Act. This 101st Constitution Amendment Act is the act through which the no GST came into picture. No, to bring GST into picture, there were some constitutional amendment required. That constitutional amendment was done through the 101st Constitution Amendment. Now, what is the interlinking between the basic structure doctrine and the 101st Constitutional Amendment that we are going to cover? Now, before going into this analysis, understanding about the basic structure is very important. Recently, I made a video explaining what is this doctrine of basic structure. I am attaching the description of that video also in the description. I recommend you to watch that video first for the purpose of better understanding. But anyway, if you ask me to give a quick glimpse about the doctrine of basic structure concept, this doctrine of basic structure concept was for the very first time pronounced by the Honorable Supreme Court in the case of Keshwananda Bharati versus State of Kerala. Now, the question before the Honorable Supreme Court in that case of Keshwananda Bharati was whether the Parliament has unlimited powers to enjoy the Constitution or not. Now, for that question, the answer given by the Honorable Supreme Court was that yes, the Parliament enjoys unlimited powers, but however, the powers of the Parliament to amend the Constitution are subject to the basic structure. So it means that yes, Parliament can amend, however, core principles relating to the Constitution cannot be amended by the Parliament. For example, today government want to change India from democracy to dictatorialship leadership. Can that be done? No. Even though Constitution amendment is permitted, you cannot touch the core principles of the Constitution. Democracy is one of the core principle or one of the basic structure of the Constitution. So this is what the Supreme Court had said in the case of Keshwananda Bharati. However, the Supreme Court didn't clearly mention what comes under basic structure. Frankly speaking, the term basic structure is also nowhere present in the Constitution. The term was for the very first time used by the Honorable Supreme Court only. But Supreme Court in various judgments had analyzed what comes under the basic structure. Like equality comes under basic structure. Democracy comes under basic structure. Free and fair election comes under basic structure. Federalism comes under basic structure. Now, these are the core values or core principles of the Indian Constitution, or the drafters, the drafting committee or people who had discussed in the Constituent Assembly had considered these as the core principles or core values of the Indian Constitution. Okay. Now, keeping aside the basic structure and before analyzing how is it is interlinked or how is it is linked to the 101st Constitution Amendment, I just want to quickly highlight a few important points that were there in the Moit Minerals case, the part of the ultimate judgment of the Supreme Court. Now, in that judgment, the Supreme Court had said that the recommendations of the GST Council are not binding in nature. Now, if you observe the highlighted word that I have, the sentence that I have highlighted on the screen, to regard them as binding edicts would disrupt the fiscal federalism. So, if you are considering them as binding, having binding effect, then it would disrupt the fiscal federalism, is what they have said. And also in the last paragraph, what the Supreme Court had said was, the government, while exercising its rule-making power, is bound by the recommendations of the GST Council. However, that doesn't mean that all the recommendations of the GST Council made by the virtue of Article 279A are binding on the legislature powers to enact primary legislation. Now, what the Supreme Court had said was, now the recommendations of the GST Council, which is resulting into secondary legislations like rules, notifications and all, those are binding. But the recommendations which are made, for example, we generally say that CGST Act and all the states SGST Act are similar. There is no any difference. Each and every section are same. Okay, so this is what coming through Article 246A, which we will discuss it detailedly. Now, what the Supreme Court had highlighted in the Moit Minerals case was whatever the recommendations which the GST councils are making with regard to the primary legislation, that is the sections in the act, those recommendations are not binding either on the parliament or neither on the parliament nor on the state legislatures, is what they are saying. It means, for example, in GST council they have made some recommendations with regard to amendment of a particular section. The recommendations of the GST council are not binding. It means, for example, one particular state legislature had decided that no, we don't want to do amendment to that SGST act of our state. Okay, so that stance, can that particular state legislature can take that stance? Yes, absolutely they can take. This is what the Moit Minerals case had said. Now the question, why the actually speaking, the intention of bringing the GST was to ensure that there is an uniform tax structure in the entire country. So and the entire one nation one tax, in simple words I can say. So that was the idea behind introducing GST. Then why again this kind of argument is coming that the recommendations of the GST council with respect to the primary legislations are not binding? No, your objective of bringing GST legislation is to bring the entire country with regard to the indirect taxation as a one, one state or one nation, one tax cutting, uniformity you want to bring. Then again, why this discrepancy, or why this inconsistency, or why this, disruption is happening? Why there was a different again argument saying that, not even argument, it was a conclusion part, that the recommendations are not binding. Why such point came? Now, before going into the background reason, the reason why the Supreme Court had said like this was, if you observe here, the Supreme Court had categorically said that neither Article 279A begins with a non-obstant clause, nor Article 246A states that it is subject to the provisions of Article 279A. Now, what is Article 279A? Article 279A is the article which had we generally see that GST Council is a constitutional body. Why it is a constitutional body? Because about the GST Council, it was directly mentioned in the Constitution, that is under Article 279A. That is the reason why we call GST Council as a constitutional body. Now, through Article 279A, as I said, through 101st Constitution Amendment itself, GST had came into picture. At that time, there were some amendments made to the Constitution. In that, one of the amendment was introducing Article 246A and Article 279A. Through Article 279A, they have incorporated a constitutional body called the GST Council, where both the center and state will sit together. They will come to a common understanding, and they will make some recommendations. Based on that recommendations, respect to primary legislations and secondary legislations will be issued by the respect to both the parliament as well as the state legislatures. This is what the rough idea we are having. Okay, so now what the reason why the Supreme Court had said that those recommendations are not binding? So they have said that neither Article 279A starts with a non-obstant clause, nor Article 246A, which is giving the power for both the parliament as well as the state legislature, had said that our power is subject to Article 279A. For example, if you observe here, Article 246A, what it has said was, notwithstanding anything contained in Article 256 and Article 254. Now, this Article 246A is the article which is giving power both to the parliament as well as the state legislatures to levy GST. Now, this article, in these articles, nowhere it is mentioned that this power is subject to the recommendations made by the GST Council through Article 279A. The wordings was the power they have given was an absolute power. It is not subject to the recommendations. If the intention of the lawmaker, or if the intention of the parliament was to give the power subject to the recommendations made by Article 279A, they would have used the words that Article 246A. See, if you observe here, Parliament and the legislature of every state, Parliament and the legislature of every state have the power. Every state have power to make laws with respect to goods and service tax imposed. So, notwithstanding anything contained in Article 246 and Article 254, they have used, and they have given power to the parliament as well as legislature of every state to make laws with respect to goods and service tax. And this power, nowhere they have said that this power is subject to what was given in Article 279A. And neither Article 279A, neither Article 279A starts with the word, starts with a notwithstanding clause or non-obstant clause. No, it means that 279 is also not having any overriding effect. At the same time, 246A also not saying that their power, whatever the power Article 246A had given to the parliament and the state legislatures are subject to the recommendations. That wordings were also not there. Now, as the wordings were not there in that way, we are saying that the recommendations of the GST Council with regard to the primary legislations are not binding. This is what the Supreme Court had said. Now, the basic question which comes to our mind was why the parliament had done like this. Is it a drafting mistake or is it purposefully done in that intention? Because this in one way looking, I can say that in my humble opinion, one way, it is creating an anomaly. That you are saying that it means that if tomorrow any state government, for example, recently the GST Council had decided, not recently, the very famous thing which we all know, that the safari retreats, plant and machinery, explanation to section 117 subsection 5 clause D, they have used the word plant or machinery. That plant or machinery, they have decided to amend it as plant and machinery. This was no recommendation given by the GST Council. Let us assume Andhra Pradesh state government or Telangana state government doesn't want to make that amendment. Yes, it is technically possible. This is what is our understanding and also supported by the Supreme Court judgment in the case of Moit Minerals. This is absolutely possible. Now, in this context, the question that can come to us was, is it purposefully done or is it a drafting mistake? Now, here comes a beautiful reason. Now, in my humble opinion, it was not any drafting mistake. It was purposefully done. Why it was purposefully done? What was the reason behind that? Now, the reason is very simple. It is doctrine of basic structure. Here comes the beautiful interlinking between the doctrine of basic structure and the 101st Constitution Amendment. Now, how is it? Okay, Harsha, you are saying that this was the reason it was done purposefully. Then why? Why it was purposefully done? What if I say, what if the parliament had drafted the 101st Constitution Amendment in such a way that the recommendations are binding? What would have happened? No, you know what would be the ultimate result? The ultimate result would be this 101st Constitution Amendment would be struck off by the Honorable Supreme Court if the case had happened, or if Article 246A they have said that it was subject to the recommendations made by the GST Council. If the drafting was done in such a way, then there would be a very, in my humble opinion, there would be a very good chance of this 101st Constitution Amendment got struck by the Honorable Supreme Court, stating that it is unconstitutional. It is, overlooking, or it is not qualifying the test of basic structure. In my previous video also I have highlighted that every Constitution Amendment should have to pass the basic structure test. It means that whenever I am making any constitutional amendment, it should ensure that it is not disturbing the basic structure. Okay. Now, I mean to say that if the parliament had drafted the 101st Constitution Amendment in such a way that it had given the binding effect to the recommendations of the GST Council, then it would have not qualified the basic structure test. Now, why basic structure is coming here? All these things we will understand first. Now, very important point which you have to understand before going into this was, the Honorable Supreme Court in the case of S.R. Bommai versus Union of India had said that federalism is also part of the basic structure of the Constitution. Now, what is meant by federalism? Federalism it means that separation of the powers between the union, state and the union. Now, union had a different set of powers and the state has a different set of powers. Now, if you see Schedule 7, there is union list, there is state list, and there is also concurrent list. Now, whatever the items are there in the union list, the exclusive power to make legislations with that union list rests with the parliament, and the exclusive power to make laws with respect to the items mentioned in the state list is with the state legislature. This is a separation of powers. it comes general administration matters and also the tax matters as well. Now why it was done in that way? Because states are also given some revenue powers and as well as also administrative powers, exclusive powers. So what encroaching parliament encroaching the state legislated powers. For example, in GST we all say that land and building was kept outside the ambit of GST because it is an exclusive subject matter of state. Now if I bring that into GST, what will happen? Center also will get the power to levy GST on land and building. It is nothing but encroaching the power of the state legislature or state legislatures, which is against the concept of federalism. This is what we generally say. So I am trying to explain what is federalism. Federalism is nothing but the separation of powers between the parliament and the state. No, federalism ka breach should not happen. It should work in true spirit. That is what we are saying. And breaching federalism, as federalism being the part of the basic structure, breaching federalism would create legal problems to the parliament as well as the legislatures. This is what I'm trying to say. Now if you observe the 101st Constitution Amendment, generally if you observe all the taxation laws in India, you take income tax, you take customs duty, and even before GST coming into picture, if you take excise duty, even if you take service tax, all of them, all the power to parliament to make all these laws comes from Article 246. Article 246, through Article 246 it is linked to Schedule 7. Schedule 7 mein union list is there, state list is there, concurrent list is there. But GST, if you see, it is coming, the power to both the state and parliament is coming through Article 246A. It is not coming from Article 246. Now why they have altogether introduced Article 246A? Why they couldn't continue with Article 246? What was the reason? Now, for understanding this, I just quickly take you to the picture what we had before the 101st Constitution Amendment. Now, before the 101st Constitution Amendment, there was an entry called Entry 84 in the Union List, which is given power for the excise duty. Now, what it is saying, duty of excise on tobacco and other goods manufactured or produced in India. Now, this entry, by using this entry, the Parliament had got the power to make excise law. Now after amendment, what they have said, the duties of excise had restricted only to these goods. Earlier excise duty levying power was there on all excise on tobacco and other goods manufactured. It covers all of the goods. But now after the amendment, the excise duty was restricted only to these products. Now we all know that GST had subsumed the excise duty. How it is subsumed? Because of this amendment it had subsumed. Okay, because of these entry amendment and also 246A. Okay, so through this way it had done. Now also the earlier taxation on the sale of goods, the exclusive power is with the state assemblies with respect to within the state sale. Now before amendment, before the 101st Constitution Amendment, entry 54 of state list 2, this is the entry which had given power to the state legislatures to make laws with respect to make taxation laws with respect to sale of goods. Taxation on the sale or purchase of goods subject to the provisions of entry 92A. That entry 92 is with regard to interstate supply. Now see, after amendment what happened? So it is restricted only to the sale of petroleum crude, high speed diesel, natural gas, aviation turbine fuel, alcoholic liquor for human consumption. So it was restricted. See, before the amendment, before the 101st Constitution Amendment, excise duty, central has the exclusive power. Service tax through entry 92C subject to correction. Yes, 92C it was. This is the entry. 92C was also omitted. So entry 92C had given the parliament. Both the excise and service tax is law-making power or taxing power is with the center. Excise it is through entry 84 and service tax it is through entry 92C. And similarly, the state has the power to levy VAT under entry 54 of the state list. See, This was the picture before 101st Constitution Amendment. Now, through GST, I have to give power to both of them, both the state and both the parliament. We all know that there is another list called concurrent list. Now, if anything is there in concurrent list, both the state and both the parliament will have the power to make laws. Many people till today think that these excise and all, sorry, this GST was there in concurrent list, thereby both the parliament and state is having power. No, it was not there in concurrent list. This was the general thought which will come to us, that they can simply keep these all things in concurrent list. Through concurrent list, not all these things like taxing with respect to the supply of goods and services can be kept in a concurrent list. When it is kept in concurrent list, both the state and both the parliament will get the power to make laws. Thereby issue could have settled, is what we generally think. But it was not done in that way. No, what was the reason why they have not done? Why they have altogether brought an article called Article 246A? Because state list, union list, concurrent list was governed by Article 246. If they would have kept these all these things in Article 246, concurrent list, that taxing power of goods and services, there is no any need of making Article 246A. But still, why government or the parliament went with the bringing Article 246A instead of keeping it in concurrent list? The reason is basic structure. Why? Now, for understanding this, you have to understand an important article called Article 254 of the Constitution. A very, very important article which had changed the entire picture of 101st Constitution Amendment. So now, inconsistencies between law made by parliament and law made by the legislature of states. If any provision of law made by the legislature of a state is repugnant to any provision of a law made by the parliament, let us assume 101st Constitution Amendment was made in a way that in concurrent list they have kept a tax on goods and services. Okay, this is how let us assume the entry was given. Now what will happen? Both the parliament will have the power and both the state will have power. For example, let us take one particular state had made some amendment in the GST law, and that GST law related amendment was repugnant. Repugnant means inconsistent or deviating with the central law. So what they have said, if any provision of a law made by the legislature of a state is repugnant to any provision of a law made by the parliament, okay, which parliament is competent to enact to any provisions of the existing law with respect to the matters. Now, in such scenario, what will happen? What they are trying to say was, if anything there is in concurrent list, both the state will have the power and both the parliament also will have the power. Now, whenever they are having power, there can be a very high chance of getting inconsistencies between the center as well as the state laws and central laws. Now, in such scenario, what Article 256A is saying, that the law made by parliament, okay, whether passed before or after the law made by the legislature of such state shall prevail, and the law made by the legislature of the state to the extent of repugnancy be void. Simply speaking, what Article 254 is saying now, Article 254 is giving the law made by the parliament an overriding effect. So, if the GST was brought by making an entry in the concurrent list like this, what would happen now? If any inconsistency was there between the legislation drafted by the state and legislation drafted between the parliament, the legislation drafted by the parliament will have an overriding effect to that inconsistency. Okay, let us assume they have done like this and there was an effect. Now you can ask me a question that this is resolving the issue, no, anyway. Inconsistency is there, anyway we have to sit and resolve. But Article 254 is directly giving that resolution, no, it is giving that solution, no. Why the parliament had missed this aspect? See, giving parliament an overriding effect means nothing but parliament literally encroaching the power of the state. Through GST, see, GST was a combination of powers, bringing together the powers of both the parliament and state. Excise and service tax power was with the center. Taxation on goods, both was power was with the state. No, they both are giving simultaneously, they are giving permissions. Like I am giving access to my powers, and you are taking access no, for my powers. This is what it had happened. Now whenever I have kept this in concurrent list and any overriding effect is given, then it is literally parliament encroaching the power of the state legislature. Now goods related power, I am having state is having that exclusive power, but through using article 254, you have said that there is an inconsistency. Because of that inconsistency, the law made by the parliament will have an overriding effect, and it is overriding. In such case, what will happen? This, in my humble opinion, this can be a breach of the no federalism, which is the basic element of the, or which is the element of the basic structure. Now federalism itself means the division of powers. Now one is encroaching the other one's power. So this is the reason why they didn't kept this under concurrent list. Instead they have kept it through a separate entry called article 246A. In this also, if you observe the wordings here, they have said that notwithstanding anything contained in article 256 and article 254, they have given overriding effect to article 254. Why overriding effect to article 254? They don't want parliament to encroach the power of the state, or they don't want the parliament law to have an overriding effect than the state law. That is the reason why instead of putting it in concurrent list, they have kept separately through article 246A. If they would have kept it in concurrent list, then article 254 will come and hit all the inconsistencies. In such scenario, it is nothing but parliament encroaching the power of the states, which is breaching the concept of federalism. Breaching the concept of federalism is nothing but breaching the doctrine of basic structure. As I said earlier, any constitutional amendment breaching the basic structure will be held void. This is the logical reasoning, in my humble opinion, for bringing the 101st constitutional amendment through article 246A route rather than the route of concurrent list. So if this you can observe by the wordings, and also this is the reason why in article 246A nowhere they used the word that the power of both the parliament and state are subject to the recommendations made by the GST council. See, if recommendations made by the GST council are binding, say for example I am a state government sitting in the GST council, I don't like the recommendation made, I am the only state which is disagreeing. No, if the recommendations made by the council with respect to the primary legislation itself is binding, then it is literally, they are the people sitting in the council, that is the parliament and the other states, are literally taking my power as a state legislature. So this is not the very basic idea. This is against the very basic idea of the federalism, which the constitution don't want to encourage. So that is the reason why the parliament had drafted the provisions of article 246A and article 279A in such a way that it is not having any overriding power, and it is a simultaneous power both for the parliament as well as the GST. Now both the parliament and GST has a simultaneous power. And also very important point, this not binding concept will not apply to the secondary legislations, that is the rules, notifications and all, those are binding. It doesn't apply to the primary legislation part. Primary legislation related recommendations are not applicable. Now again I just want to quickly highlight some important points made by the Honorable Supreme Court in the VKC Footsteps case also with regard to this aspect. Excuse me. If you observe what they have said, article 246A defines the source of power as well as the field of legislation, obviating the need to travel to the 7th schedule. No, 246A had given the power. If you refer article 246, parliament is having powers or state is having power, and the list was given separately in list 1, list 2, list 3. But here no list is required. Directly in Article 246A itself they have said that no, notwithstanding anything, legislature of every state have power to make laws with respect to goods and service tax. So they have clearly mentioned those aspects also here only. So that is the reason why the Supreme Court had said that 246A is giving source of power as well as also field of legislation also, thereby obviating the need, means no need to travel to the 7th schedule. And secondly, 246A are available both to the parliament and the state legislature. It is a simultaneous power. Okay. And also Article 246A embodies the constitutional principle of simultaneous levy as distinct from the principle of concurrence. Beautiful point, which is very important for understanding the entire idea of GST. They have said that it is a simultaneous levy which is different from concurrence. In concurrence, what will happen? To the extent of inconsistency, parliament law will have an overriding effect, which I don't want here because to pass the basic structure test. Okay, so concurrence which operate with the fold of the concurrent list, fold of concurrent list as regulated by Article 254. And also the very important point, again, all these paragraphs, all these extracts I have taken from the Moit Minerals case. Okay, so having regard to the nature of the constitution of GST Council, the Council would have performed useful role in making recommendation, but the ultimate authority whether to accept such recommendations must rest only in the state legislatures. See, these were the submissions made by the Attorney General to the Parliament when the 101st Constitution Amendment related bill was introduced. This was a submission made by the Attorney General, which clearly shows the intention behind of the Parliament for making this legislation. They have said that ultimate authority whether to accept such recommendations rest only in the legislatures, namely Parliament and state legislatures. The powers of the legislature over finance are sacrosanct. Sacrosanct means they are not disturbed. Okay, and not affected by the setting up of the GST Council. And also very importantly, presently another important paragraph, 41 paragraph of the Moit Minerals case was, presently the concurrent list in case of any difference between central and state legislation, the central legislation will prevail. These are the reasons they have said, but they didn't connect it anywhere with the basic structure. This is my opinion based on my research. What I have came for an understanding was why they have drafted the Article 246A and Article 279A. Instead, why they brought Article 246A? The reason was this: to save this 101st Constitution Amendment from the basic structure hit, they have done all these things. I hope it is clear, and thanks for watching this video. Before that, I just want to acknowledge CA and Advocate Venkat Prasad Pasupuleti sir for his inputs. Like he had given me a tip of, not to me personally, while I'm working with HNA, in the internal sessions he had brought this question that why it was not kept in concurrent list and all. So that had made me to do a further follow up on research and try to interlink with this. And also I would wholeheartedly thank CA Shilpi Jain madam, partner HNA, who had constantly encouraged me for do this kind of thinking and research, especially. And also CA Lakshman Kumar sir for encouraging me in doing this kind of research and giving me the opportunities. So I would like to thank the entire HNA team where I have worked with them, where I was encouraged to do all this kind of research. Okay, I hope you all like this video. If you really like this video, please like, share, comment and give your valuable feedback. Namah Parvati Pataye Har Har Mahadev. Thank you. Jai Hind.